Hello, everyone. I'm Dwight Mitchell. I'm the founder of Family Preservation Foundation. Welcome to the Child Protection Services Pro Health Kit video series. Today we're bringing you another session on working with your attorney. I hope you enjoy the content and it allows you to better understand your rights and options as it relates to working with CPS. For those of you who are tuning in for the first time, and who don't know my story, after a 22-month battle, I successfully defeated Dakota County Social Services in Minnesota and had my children successfully returned to me pro se. It was an education, to say the least, and what I intend on doing is passing along the benefit of my knowledge and lessons learned while cross-referencing Minnesota state statute and case law, which is readily available for you to see on Google Scholar or searching on the internet. I got to put this disclaimer in. I have to tell everyone I am not an attorney. I am not licensed to practice law whatsoever, nor am I providing you any legal services. I recommend you to obtain your own attorney when you can, if possible. My video series is specifically geared toward education. I've been fighting CPS now for 5 years. I'm not going to just throw things up at you arbitrarily. I don't want you to be misguided. Everything that I say to you, I'm going to reference with either a Minnesota state statute or case law. This video series is for educational purposes only. I will go over everything from the beginning, the middle, and the end of the CPS process and what you can do in your defense against CPS. It'll be hard work for you. Nothing in this life that's good comes free and easy. So if I provide you like Minnesota templates or guidance, it's not to be used as is. Every single case is different, and so you must understand that what I'm giving you is an example. I might cross-reference what specifically happened to me or other parents. I've been to court with other parents, and I've seen what have happened. So I'm only educating you as to what some of your situation or scenarios might be. It's never the same because you're always dealing with different people, different judges, different circumstances. So remember, you're not allowed to go into court and to say, well, Dwight Mitchell told me to say this. Well, no, because I'm not a lawyer, and so I can't tell you to say and do something. The word pro se means for yourself, so I'm educating you so that you're better able to apply things to your case and do what you need to get your child back. So you're doing this for yourself, and I'm only providing you the tools to allow you to be successful like I was. So you have two choices. You can either go out and hire your own attorney. If you can't afford an attorney, the court will appoint you an attorney. So if you're working with a court-appointed attorney, Minnesota Statute 260C.163, which is for your hearings for CPS, the appointment of counsel must happen during your CPS proceedings. So if the child, parent, or guardian has the right at all times in all of our legal proceedings in the United States, has right to effective counsel. And if you can't afford that, you need to make the court aware of this, especially as it pertains to juvenile proceedings, that you need a counsel. Also, if the child is over the age of 10 years old and the child desires a counsel, the Minnesota statute says that the child is to be afforded an attorney also to represent the child's best interests. So if the parent or the guardian or the custodian desires a counsel but is unable to employ one, the court shall appoint a counsel to represent the attorney. That's a public defender. Look at section 611.17 of the Minnesota State Statutes that I was just referencing. You can also look in the handout. I expect everyone to be following along with the handout that goes with this video series. So you download the handout and you're following along as I explain to you the process as it relates to working with your attorney. So In any proceeding where the subject of a petition for a child is in need of protection or services and the child is 10 years or older, that the agency or the court must appoint that child its own attorney, separate and apart from your attorney, to represent that child's best interest. It happened to me in my case. I have mixed feelings on that. I can only tell you in my particular case, because I have the documentation, that the county attorney and the social worker and the guardian ad litem, they were all drinking out of the same coffee pot. If you want my humble opinion, they were all working together. So it really is going to be up to you to ensure that your attorney is doing what you want. And I'm going to tell you what to do as it relates to that later on, to ensure that your attorney is always working in your best interest, and how to effectively work with your attorney. So in any proceeding where the sole basis for petition is like truancy, habitual truancy, so your child will not go to school and won't listen to you, the parent or guardians do not have the right to a public defender, which is kind of odd, because if you can't control your child, then they're saying, well, you don't, the attorney will take over for the child. So there's a balance in there, and I suppose that's something that has to be looked at. That's in subsection E of the statute that I just mentioned before. You have to look at some of these statutes carefully to determine whether or not a counsel will be appointed to you. If there's any court proceeding and any CHIPS proceeding where the subject is a child in need of protection or services, and it's not available, say the child is below the age of 10 years old, it's not required, but the court can appoint an attorney for the child or family if it feels it's within the best interest. If the child is over 10 and the child explicitly express the request for an attorney, then the court has to assign one. And it's the court's responsibility to ask the child if the child wants an attorney. So that is something that needs to happen also. Please keep in mind that once the court appoints you an attorney, the court is only allowed to appoint you one attorney at the county's expense. It behooves you to try and get along and work with that county attorney. Unless you have clear grounds that the attorney is not working in your best interest and not doing what you say, and you put things in writing and you could bring that before the court, then the court may substitute at its own discretion another counsel, but that is generally not the case. The state statutes, subsection 8 says the court may appoint only one counsel at the public's expense. So, if it's one counsel, one continuance counsel, if it's one for a couple, each couple should have their own attorney, both the father and the mother, so there shouldn't be one couple representing two attorneys, not unless you have a private attorney. Now, a private attorney can represent, the parents, but not when you have two. So please keep that in mind as you're moving forward, and that is working with a court-appointed attorney. Please stay tuned and look at some of our other series and episodes. This one was rather short because I was trying to talk about just, a court-appointed attorney. Some people are like, shouldn't I get an attorney? Shouldn't I get a public defender? Why wasn't I assigned one? Well, this handout and the state statutes tell you that you are allowed a public defender if you can't afford one. You're going to have to fill out an application that states your income level, and if you fall within that realm of I can't recall what the exact percentage is now, but if you fall within that realm of needing a court-appointed attorney, one will be assigned to you. Thank you very much. And please stay tuned for additional sessions on our Child Protection Services Video Pro Se Help Kit. Have a great day.